How to conduct a sexual harassment investigation by group members Raquel Gutierrez, Jose Guerra, David Hernandez, Norma Ibarra, Brenda Tristian, Liliana Castillo, Carlos Diaz, Daisy Murillo. Professional investigations. Even the best-run companies will inevitably encounter cases where they must conduct internal investigations of employee behavior. They must have proper motives for investigations, conduct investigations in a professional manner, use agents who are trained in techniques and aware of the legal standards involved. Employee conduct usually merits investigation when it is against company policy and subject to discipline as defined in employees' codes of conduct. Some examples are financial misdeeds or other misuse of company assets, abusive behavior towards supervisors, co-workers, or business contacts, or current drug or alcohol abuse. The employer's decision to initiate an investigation may be challenged if it appears to be based on one of the following protected characteristics: race, sex, national origin, religion, age, disability or handicap, sexual preference or orientation, and marital status. While some types of internal investigations are prohibited by law, others are mandated. When an employee alleges harassment based on a characteristic protected by anti-discrimination laws, the employer's defense may depend on its ability to prove to the court that it did not condone such harassment, it had a policy against it, and it took action to prevent or correct the harassment. The United States Supreme Court held that prompt and effective investigations must be undertaken when an organization is aware of a sexual harassment complaint. The court, however, offered no guidance on what constitutes a legally sufficient investigation and what procedures should be followed. Reviewing how juries and courts have responded on the adequacy and inadequacies of various company investigations can guide employers on how to handle complaints properly. In effective policy, you need to communicate, and communicate. This whole exercise is useless unless your staff knows about the policy. Recent court rulings have made it clear that a policy ignored is tantamount to a finding of liability. Distribute a harassment policy to new employees during their orientation, and providing an annual reminder to all staff is a good practice. Providing awareness training to employees and to managers is also a good practice. Ensure that every employee receives a copy of the policy by having each person sign an acknowledgement form. Some policy basics are that 1. It prohibits all unlawful workplace harassment. Is written in plain, easy to understand language. It lists examples of what is and what is not sexual harassment. Lists several persons with whom a complaint can be filed. 5. Provisions allowing the employee to bypass his or her supervisor in the event that the supervisor is the harasser. 6. Avoid any language that might discourage complaints. 7. Prohibit retaliation. 8. Confidentiality to the maximum extent possible. Require an immediate investigation of allegations. The employee will be informed of the results of the investigation. In conducting a proper investigation, it is best practice to have a written complaint from the reporter as early in the process as possible. During your investigation, it is important to reiterate the policy prohibiting retaliation against any reporter or witness. You may also want to follow up with the reporter from time to time and be sure this policy is respected. Stabilize the situation as quickly as possible and protect the reporter from further harassment or possible retaliation. Assigning the respondent to another department, shift, or work area may be appropriate in the short term. In conclusion, have a written anti-harassment policy that includes sexual harassment and communicate the policy to all staff. Require staff to report violations of the policy and remain alert for violations which may go unreported but which the employer is still responsible for. Provide more than one avenue for your employees to register complaints under the policy. An employee should never have to complain to the alleged harasser. If a charge or allegation is made, conduct an immediate investigation. If necessary, contact independent legal counsel to assist with the investigation. Talk to everyone identified by the employee and the alleged harasser as witnesses. Limit the potential for continuing harm by separating the victim from the alleged harasser. If necessary, suspend the alleged harasser with or without pay pending the outcome of your investigation. Based upon the results of your investigation, take appropriate disciplinary action up to and including termination and referral of criminal conduct to law enforcement authorities. Meet with the employee to inform him or her that you have conducted the investigation and have either been unable to substantiate the claim or have taken disciplinary action.